Hello there and good afternoon. My name is Julia Graham. I'm the Deputy CEO and Technical Director at AIRMIC, and I'd like to welcome you to this AIRMIC webinar on modern slavery and human trafficking. This webinar is going to be led by Jim Lister, Partner and Head of Employment at law firm BLM. And welcome, Jim. Thank you for joining us today. We're going to walk through the opportunity for you to take questions during the webinar, Jim. And for those of you who are in the webinar now, if you look at the screen, you'll see this is how you can ask questions as you go along. We'll leave it to Jim's discretion as to whether he answers them immediately, or perhaps we park some and save them to the end if we've got several questions, Jim, on a similar theme. So without further ado, Jim, I'm going to hand over to you, and the platform is yours.
Thank you very much indeed. Welcome to a balmy city of London. It's very warm here. We're enjoying the late summer very much. This seminar on modern slavery is going to take about 25 minutes. And what I'm going to do during it is to cover, first of all, what is modern slavery. And I'm going to concentrate particularly on Section 54 of that Act, and specifically what British companies, UK-based companies, need to do in order to comply with the Act. So it's about supply chains, in essence, and I hope that was what you were expecting. I am going to touch on the definitions of modern slavery, because obviously it's impossible to identify whether there's modern slavery in your supply chains without knowing exactly what it is. So I am going to go into a fair amount of detail on that. Not excessively, I hope, but I do think it's important that that is a part of the knowledge of those individuals who have responsibilities within their companies to deal with the requirements under this particular legislation. As initial observation, can I say that this is probably the lightest touch piece of legislation that you're ever likely to see. The legislation has no sanctions. If you choose not to comply with it, nothing will, I have to tell you, nothing will happen. There aren't any fines, there aren't any provisions that punish those who don't comply with their obligations under Section 54. We'll come on to exactly what those requirements are. And the government doesn't try to hide the fact that the sanction that it expects there to be under these provisions is in the court of public opinion, essentially. If you do not produce a statement that deals with your company's attempts to remove modern slavery from its supply chains, no sanction will follow, other than you will face potentially at least adverse publicity and damage to brand and so on. Can I say, just make this observation about regulatory requirements. Whenever you're dealing with a regulatory requirement, it seems to me, you always have to imagine, what will this look like when something has gone terribly wrong? Because that's when people start to look at regulatory requirements and look at what you did. So imagine the situation in which there is publicity that your company has been involved in modern slavery, or your supply chain involved modern slavery in Bangladesh or somewhere like that. There was a fire, and this has happened in recent times, and people are going to look at you and then look at your modern slavery statement. Does it look good? Does it look like you tried? Because quite frankly, if nothing goes wrong and there isn't adverse publicity, there's a limit to how many people are going to be looking at your modern slavery statement. It's when something goes wrong that they will, and that's the point at which you need to be satisfied that you did enough. So before I move on to the meat of the thing, can I say that in terms of documents to look at, one document in particular that I'd highlight to you that it's worth looking at, in my view, there is a government guidance paper which is rather poetically entitled Transparency in Supply Chains, etc., a practical guide, readily available on the internet. The best thing that you can read on it probably tells you all you need to know, actually, in relation to modern slavery and the Section 54 duty. So do have a look at that. That would be my main advice to you, or my main recommendation to you in terms of documents that you can look at. So let's look at slide 2. Which sets out the obligation in summary. And as you can see, there it is, in keeping with that light touch approach that I mentioned, Section 54 of the Modern Slavery Act simply requires that any commercial organisation operating in the UK with a global, and I do emphasise global, turnover of £36 million or more must publish a human slavery and human trafficking statement in each financial year, setting out the steps taken to ensure that there's no human slavery or human trafficking in its business or its supply chain. Now, very often I think it's possible people forget that this obligation isn't just about supply chains, it's also about making sure that there's no modern slavery in the UK business. We'll come on to that in a little bit more detail later on, but do remember it's both. Steps to remove modern slavery both from your main business and from your supply chain.
So Jim, we've already got a question that's come through, and that question noted everything you've said about it ruled by the court of public opinion, which is what I think you said. But the question is, do organisations have an obligation to display their compliance, for example, on their website? Because the person asking the question says they see more and more of these of websites listing their modern slavery statements. What's your experience and advice in that sense?
Well, the Section 54 specifically, we'll come on to this in a little more detail later, specifically requires absolutely that a modern slavery statement must appear on the home page of the company's website if it otherwise is required, for the reasons that I'll come on to, required to make a statement. I have looked at an awful lot of companies to see whether they're complying. I've seen many companies who are putting on modern slavery statements who probably don't need to. So they're doing it almost voluntarily because it's almost becoming an expectation. I have seen a few companies, I won't name them, that are mystified by the absence of a modern slavery statement because it's not obvious to me why they wouldn't have to make one, and yet they're not. Can I suggest some international hotel chains fall into that category? And I'm not entirely sure why. I'd need to speak to them and ask them. I haven't. I think it is increasingly becoming the norm and the expectation that companies, even those not actually required under these regulations to provide modern slavery statements, are doing so. And yes, it is a requirement under the Act that if you meet the criteria, you must put a modern slavery statement on your website, and it must be there must be a link to it on the home page in a prominent position. Now, that's what the Act says. All I'm saying is if you don't do it, there is no sanction. Now, some would say a law with no sanction is scarcely a law, but there we go. That's
I guess one of the sanctions, I know you're going to cover this later, but one of the sanctions could be that if you're in a supply chain arrangement and have a contract with somebody you supply, and that contract says that you should do that, then I guess in the supply chain, the organisations that agree that contract, in effect, could oblige you to do this.
I think that's a very important point. We must remember there are statutory obligations and there are commercial obligations and commercial imperatives. And what we often find, particularly in public procurement, any company that wants to apply for any public sector work, local authorities and so on, almost inevitably these days are going to be required as part of that tender to show what their modern slavery credentials are. Now, that will include making a modern slavery statement. It will include having a policy. And I would say now, even today, it is pretty unlikely that you're going to get a public procurement tender successfully unless you can demonstrate credentials in relation to modern slavery. So that is far and away the more effective way that this is going to be enforced. In many ways, this Act is a little bit of a paper tiger. It's that commercial imperative. Are companies going to start to insist that their commercial partners demonstrate their credentials? That's what's going to force the agenda on this issue, it seems to me, not necessarily this Act. But sometimes legislation creates the culture, creates the atmosphere. So it is important, but it's a very good point that you made. Just looking at the obligations in more detail, and this we've already touched upon it, so I shall race through it. The central obligation is to provide a written statement setting out the steps the company has taken to eradicate modern slavery from its supply chain and from its own business. The statement must be produced for every financial year that falls after the 1st of March 2016. So those obviously who fall into the category because of their turnover should have been doing this already, but it only applies in relation to those financial years during which the organisation had a turnover of more than £36 million globally. That is a very small number of companies in this country. I think it's always salutary to remember that despite the fact that there are 5 million businesses operating in this country, a very, very small proportion of them have a turnover of £36 million. It's perhaps no more than 4,000 organisations in the UK who are actually required under this legislation to produce statements. Many more are doing so, is my experience, simply because they think it is morally the right thing to do. And as we said, because commercially it can be expedient, shall we say, to make sure that you're demonstrating those credentials. So that is the essence of the obligation. The statement doesn't need to be made in any particular form. Many statements I see these days, particularly for larger companies, are deliberately generously illustrated photographs, visually arresting material, because these companies think it's very important to demonstrate what they're doing. Of course, you don't want your rival companies to be looking more impressive than you in this particular regard. So you are seeing really quite extensive modern slavery statements. I'm bound to say that a lot of the modern slavery statements I'm seeing, and I'll come on to this later on, are covering general points of what I would call corporate responsibility, rather than specifically those things relating to modern slavery. Nevertheless, you would say that must be a good thing. The statement has to be approved by the board in a board meeting. I would therefore always recommend that it's a minuted item, and it's passed as a resolution. That would seem appropriate, and it must be signed by the chief executive or equivalent if the organisation isn't a company. Generally speaking, you'd be talking about the managing partner or senior partner of a limited liability partnership, because generally speaking, it's only going to be limited companies, whether limited by shares or guarantee, or LLPs that are going to fall within the scope of this legislation. The statement has to appear on the company website, and as I've mentioned already, there should be a clear link on the home page, prominently placed, that is the requirement in terms of publication of the main ones. We'll come into a little more detail if we have time later on. There are no criminal sanctions in relation to compliance. No, in fact, there are no sanctions at all. It has been suggested by some commentators that a company that completely failed to produce a statement could be required by injunction by the government to produce one. I'm not sure I agree with that, and certainly I don't anticipate that it's going to happen. I'm not aware of any government agency currently policing these things. I think what we might see in the future, though there's no expectation of it at the moment, is that the government may introduce a system rather like they operate in relation to national minimum wage at the moment, where they name and shame companies that are not seen to be meeting their obligations. I should point out, not only is there no obligation, or is there no sanction for not making a statement at all, I don't think there's actually a sanction for making a statement and it not being true, which is rather disturbing. But there we are. Publicity will out, PR will out, investigative journalists have a funny habit of catching people out. Not many companies are going to want to fall into that trap. Without further ado, let's look at what modern slavery is, because it's very difficult to exclude modern slavery from your supply chains if you don't really know what it is, and let's look at that. The main meat of the Modern Slavery Act is dealt with creating primary legislation, primary criminal offences, and they are very serious ones. You can go to prison for life if you are involved in modern slavery in the UK, or you can go to prison for 10 years if you're involved in people trafficking, the slightly less serious offence, though still very serious. We'll look at each in turn. When we talk about the definition of modern slavery, of course, it's not necessarily because there's a risk that the company is going to commit the principal offence. But as I've mentioned earlier on, you can't rule out that possibility, and the obligation is to avoid being involved in modern slavery in your main business. And I'll come on to that in a little more detail. Bear in mind that the best estimates in the UK are that there are approximately 13,000 modern slaves, terrifying thought, in the UK at the moment. There have been an awful lot of publicity over very sad situations where people, very often vulnerable people, drug addicts, alcoholics and so on, are befriended by people, supplied with drugs and alcohol, and used in effect to provide unpaid labour in certain industries, construction, tarmacking, these sorts of things. You can't rule out the possibility that you could get involved in those, and many companies would be well advised, even in relation to their UK businesses, to use only quality recruitment agents, avoid using unregistered or unregulated gangmasters, these sorts of things, because there is the risk, I wouldn't rule it out, of the possibility at least of being inadvertently involved in modern slavery, even within the UK business. There are three types of offence under the legislation. The third one is the most important, is the one I'm going to talk about in slightly more detail. But let's look at the first two of them. You can see that the three offences are slavery and servitude, forced labour and human trafficking. And the offence is committed where a person requires another to carry out labour if he knows or ought to know that that person is being forced or coerced to carry out that labour. Now, an important part of the legislation in relation to all three separate criminal offences is that the ostensible consent of the person to carry out the work does not preclude a determination that they're carrying out forced labour. It's the nature of forced labour that people are forced to consent, if you will. So the fact that people appear to be consenting or are even being paid for their work does not negate the possibility that they are that those people are involved in modern slavery. I would just observe at this point, I've been involved in cases where individuals have been prosecuted under the Modern Slavery Act in relation to the primary offences. And I can tell you from my experience that even when all the documents are there, and even when there's a 6-day trial, it is incredibly difficult to identify whether modern slavery has taken place. Detailed evidence goes into whether that person was allowed to make choices, whether they could leave the home, whether they were allowed to travel, what they were paid, how their life, in all its aspects, panned out. And even with all of that information, it was very difficult to know whether somebody was being subject to modern slavery. Trying to do that in the context of a foreign country where the culture is different, the language is different, is immensely difficult. And I have the very greatest sympathy with UK companies who are invited to try to discern whether modern slavery is going on in their supply chains. It's an incredibly difficult, complex, nuanced offence, and really, really difficult to identify. And I think that's the reason why the government has taken such a light touch here, because it recognises that in reality, and with the best will in the world, it is very difficult to identify always whether slavery is going on in your supply chain. Let's just look at the offences, each one of them in slightly more detail. The first of the offences is slavery or servitude, construed in accordance with the European Convention on Human Rights, and relates to those cases in which people are denied their liberty or forced to provide services or are treated as being owned, perhaps being traded between gangmasters or traded between operators. This is the limb of modern slavery that perhaps comes closest to our conventional view of what slavery is. And the government guidance also makes clear that debt bondage is a form of servitude. That's to say, an arrangement where somebody is in debt or a family is in debt and are required to work to pay off that perceived debt. That is a very common form of slavery and servitude. The second, looking at the second limb, or the second offence, and on the next slide, that of forced or compulsory labour. To me, that largely overlaps with the first one. And I don't think there's an awful lot that needs, the definition is slightly wider. It relates to labour which is extracted by coercion, oppression or deception. It's a little bit wider, but I think most types of slavery would meet both definitions. So I don't think it's particularly useful to think of those two as being particularly separate. The one that is separate, I think, and which needs careful consideration is that of human trafficking. The criminal offence of human trafficking takes place where travel is facilitated or arranged with a view to that person being exploited at their point of arrival. The person arranging the travel does not have to do the exploiting. He merely needs to know that somebody else will exploit the worker at the end or at the end point. Very often, of course, the person doing the exploiting will also be arranging the travel, but it doesn't necessarily follow that that's the case. I mentioned that human trafficking was the most common type of slavery that is likely to be identified, and that's because the definition of exploiting is very much wider than the definition of slavery. So remember, human trafficking, arranging transport with a view to that person being exploited. Now, somebody's doesn't necessarily need to be in modern slavery to be exploited, and that's the issue, and that's why human trafficking is wider. As I mentioned early on, it carries an offence of 10 years rather than life, so it's marginally less serious. Just looking on the next slide, at the meaning of exploitation in a little bit more detail, we can see that the first limb, subjecting a person to force, threats, or deception to induce him to provide any service, is pretty much the same as the other previous two limbs that we've talked about. So I don't think that in itself takes us very much further. But it must be said that in relation to a single sort of transaction, if I can put it that way, it's perfectly possible that a person who arranged the travel is guilty of the offence of human trafficking as well. But the person who carries out the force, threats and deception at the end is guilty of the primary offences of slavery and force or forced and compulsory labour. The second limb of exploitation, I think, is the most interesting and significant. A person is exploited if, by reason of the fact that they are a child or disabled, or because of a particular family relationship, they are induced to provide services where it was unlikely that a person who was not so disadvantaged would have provided those services. That's what the Act says. I think that particular definition places child workers in a particularly high risk area, because it seems to me quite likely that any child who's put to work is likely to be doing so in circumstances that an adult probably wouldn't have done it, perhaps because of the low pay or the conditions or the working hours. By its nature, child labour is often exacted because people don't complain, and they'll work cheaply and they'll work in conditions that adults wouldn't work in. And therefore, it does seem to me that whenever a company identifies child labour in its supply chain, I think alarm bells should ring, and one should think, actually, is it not even more likely than not that child labourers in our supply chain are probably being subject to exploitation? And that means that if somebody arranged their travel, then that's modern slavery. So I think if I was to point out one area where it's very easy to spot issues, I think it's in relation to child labour. Child labour, according to UNHCR definitions, anyone under 18. So I think that is particularly important. So that's modern slavery. That's the things that you're looking out for. Let's just look at who has to publish a statement. A limited company or partnership which supplies goods or services and which carries out its business or part of its business in the UK and which has an annual turnover of £36 million. That's who must publish it. So who doesn't have to? A local authority. A public body, a public sector body doesn't need to. Many people regard that as an omission, and there is, working its way through Parliament, a private member's bill that may or may not change that. But at the moment, it's effectively private sector businesses. It'll generally include charities, incidentally, because they normally operate through a company limited by guarantee, and these days they're generally involving services.
So Jim, we've got a question that's come in, which is around this subject of annual turnover of 36 million or more. As you said before, that's only 4,000 out of the, I think,
5 million or so. Yes, that's right.
That exist in the UK. So, would you recommend that companies all produce a statement, regardless of their turnover, or other criteria required by law? What do you tend to say when people ask you that question?
If you are intending to seek public tenders for public work, I would produce a statement whether you're required to or not. If you are what I would call what is commonly called a B2C business, that's a business to consumer business, I would produce a statement, because consumers increasingly are going to expect that the companies they deal with and they trust are dealing with these things appropriately. B2B businesses, that's business to businesses, I don't know. It's a matter for them. But I think it will increasingly become an expectation, because people don't know what your turnover is. They don't know why you're not making a statement. They look at the bottom of your homepage and there's no modern slavery statement. Why? Because they're used to seeing it with everybody else. Why are they not seeing it with you? They're not going to know it's because your turnover's 34 million, not 36, or because you are not counting group companies and subsidiaries into the turnover. So I would recommend, and I think the government certainly recommends, that people default to making a statement. Heavens above, for the reasons we'll come on to later, it doesn't take long. It's not a big job. So I would recommend it to people, even if they don't have to specifically do it. Just a little bit more in terms of turnover. I think the simple way that I can put it is that a UK company must count in its turnover its subsidiaries, whether they're in the UK or elsewhere, but it doesn't need to include its group companies. I know it's a rather subtle distinction between subsidiaries and group companies, but company secretaries know the difference. It depends whether the company is controlling other companies or is merely a part of a wider group. So you must include all of those companies that are your subsidiary companies. If you are a UK company and you are a subsidiary of a foreign company, and that's many, many companies, you do not need to make a statement unless you yourself have a turnover of 36 million independently. You do not need to count the turnover of your parent company or parent companies abroad, though, as I say, many people will choose to do it nevertheless. I can miss out that next slide about international companies because we've just covered that, I think, largely. Let's just look at what we mean by a supply chain. This is something of a digression, really, because it's a very interesting, I think it's an interesting and worthwhile point, but it's not one that companies are picking up on particularly. The Act requires that a relevant company reports on its supply chain, but that term supply chain is not defined in the Modern Slavery Act. The government just says a supply chain carries its everyday meaning. If you look at the Oxford English Dictionary, you don't find an everyday meaning of supply chain. And if you try to find one, you can look online. The one I've borrowed is from Wikipedia, and it defines a supply chain as a system of organizations, people, activities, and resources involved in moving a product or service from supplier to customer. Well, what companies are doing very often, if you look at their statements, is actually including not just their supply chains, but very often the items that they buy. And I think the reason they're doing that is it can be so difficult for many companies to identify what its supply chain is, particularly if they're involved in financial services and other things, that what they're very often doing is to present, can I put it, easy wins, or demonstrate that they're doing things that will very often talk about things that they're buying, their procurement practices, rather than their supply chains. And the example I've given here is Barclays Bank, which, and this is no criticism, it's entirely meritorious. They refer in their modern slavery statement to the risk areas that they think they're involved in and say that they've looked very carefully at their suppliers of corporate uniforms. Well, that's great, but I don't think that's part of their supply chain. I don't see how corporate uniforms, stationery requisites and other things are part of a supply chain. The Act doesn't say you should examine modern slavery in your procurement, it says in your supply chain. Now, for many organizations, that leaves it very little to say. And my experience is that companies want to say things. And if they have very little to say about their supply chains, what they're very often doing is widening it out into procurement so they've got something to say. It's a good thing, but they're going further, I think, than the Act actually requires. So let's look at what should be in your statement. This is the real meat of it. On section 54.5, there is a list of there's a list of suggestions that the company gives as to what might be in your statement. It's the only guidance that you get in any written material, and it says a statement that the an organization's slavery and human rights trafficking statement may include information about the organization's structure, its business and supply chains, its policies in relation to slavery and human trafficking, its due diligence processes in relation to slavery, the parts of a business and supply chains where the risk of slavery is particularly high, its effectiveness in ensuring that slavery and human trafficking is not taking place, and the training that it makes available to its staff. That is what you will find in all statements. In terms of what you should put in it, I am somebody who has no shame when it comes to appropriation of the work of others. My way and approach of dealing with these things when I'm asked to draft modern slavery statements, first of all, I speak to the client, but then I look at what other people in that sector are doing, because I want to make sure that my client is not producing a statement that is less effective and less impressive than similar companies. So I shamelessly look at what other people are doing, and if they're making good and sensible points, then I'm inspired by those and produce something similar. So I think that would be my recommendation to anyone charged with responsibility for drafting these things. Print off other people's, see what other people are doing, and make sure that yours are no less good than that. Some of these things are very short. My own organisation, the Law Society, has a statement that covers just over 20 lines. Other companies that have very extensive supply chains do very, very extensive things. Tesco's, for example, produces a very detailed and impressive report, as you would expect that they would. That is very much a matter of choice for individual companies, but the bigger the supply chain, you would expect that to be dealt with in slightly more detail. So just look at the common elements in modern slavery statements. My experience is it's common for the statement to start with a general summary of the Modern Slavery Act, what it is, and a general statement that the company supports those objectives. It's common, particularly where the company is a consumer-facing company, to contain sections relating to what we might call corporate citizenship. There's often statements covering other issues about human rights, equal opportunities, diversity, minimum wage, these sorts of things that have got nothing to do with modern slavery actually, but places the company as a good corporate citizen. It's almost an opportunity to state your case as a good corporate citizen and detail the things that you do. Very often the statements then move on to describe their supply chains, and very often will identify those parts of their supply chains that they've particularly identified as being risky. And I've mentioned on this slide here some particular areas that are notoriously and is generally recognized as being risky: agriculture, textiles, construction, and mining. Those are particular industries where that there are particular risks. Just looking on to the next slide, as well as sector risks, the other main risk area is geographical risks, and it is worth looking on the extensive material there is dealing with where the real risks of modern slavery are, which countries, and it has to be said that Africa and Asia are the countries which by general consent tend to be those with the greatest risk. And I have set out on the subsequent slides there, I'm not going to go into them in any great detail, indications of the levels of modern slavery that exist in different countries, so you can get a flavour of those areas that are particularly risky. Now, you can see there Eritrea, allegedly, it's very difficult to assess these things, 10% of the population of Eritrea perhaps in modern slavery, North Korea over 10%. What companies are probably going to want to do is to look down those and say, well, where are our supply chains? As things exist, few UK companies, except in mining generally, have supply chains in Africa. But when you look down the list in Asia, Afghanistan, Pakistan, Cambodia, Thailand, Laos, Philippines, these are countries that very often companies do have supply chains, and those are the risk areas. It is a good practice to concentrate on those areas in your statement that are the highest level of risk. Even just looking at Europe, in case we get in any sense complacent about the risk of slavery in Europe, some figures here that give pause for thought. Countries like Macedonia, Greece, have as high a level of modern slavery as many African countries. And as a point of comparison there, there are the figures for the UK by Global Slavery Index. Can I just say, as an observation, this tells you how difficult it is to get a flavour for what modern slavery is going on. According to Global Slavery Index, 2.1 people per 1,000, 200,000 modern slaves in the UK. That is not right. The commonly accepted number in the UK is 13 or 14,000. And I think we can generally say that that figure of 2.1 by Global Slavery Index, which is an NGO and well respected, is wrong. How wrong are the other figures they give? We simply don't know. But those are the risk areas, and it's good to concentrate your statement on those areas that are particularly at risk. And finally, just a few points on what common elements should be in your slavery statement. on this next slide. A summary of your supply chain, explaining exactly what your supply chain consists of and identifying the geographical risks. There's nothing wrong with limiting your statement just to those risk areas. A description of the due diligence process that you've adopted, perhaps talking about supplier or sub-supplier visits. If you've not done visits, telephone interviews. Questionnaires and statements. Again, it will be an expectation that you are challenging your suppliers in your first and second tier supply chain as to what they're doing. A requirement is, it's a commonplace now for your suppliers and supply chain components to enter into a supplier slavery agreement with you, not to involve themselves in human trafficking and slavery. And those are, without shadow of a doubt, far and away the most common steps that people are taking. What you very rarely see is supplier visits. Tesco's do them, some supermarkets do them, but very little else do. So the level, when you're sometimes very rigorous about these things, you notice that a lot is being said about what's being done, but when you look at it really closely, it's rather less than you might think. And I think finally, a statement about training and a statement relating to child labour. The final slide we've already talked about, talks about publishing the statement. We dealt with that in an earlier question. So that really does cover everything that I wanted to say about supply chains. I have to say, it's one of those areas where even if we had very much longer, it wouldn't have been possible to say any more, because it is really quite a distinct and quite a discrete area. And that is it.
Wow. Well, I mean, thank you very much, Jim, for walking us through at great pace an interesting subject. A number of our members have said that they wanted this subject to be covered in a webinar, so we're very grateful for you doing that. Just to let people know who are on the webinar, we will be publishing a copy of the slides that we used today and a recording of the webinar that Jim has delivered. And then I'd ask you to do one thing, is please, at the end of this webinar, there is a questionnaire, a feedback questionnaire for you to complete. It's really helpful for us to know what you think about our webinars so that we can continue our striving to improve them. Last but not least, also, we're publishing a short paper that Jim has helped draft. That will be going also onto our website, and it just provides a quick aid memoir. If you want a 2-pager to give to leadership in your organisation, I think that would do the trick. Now then, Jim, just before you finally escape, one final question that's come through. I'm just going to beg 2 minutes of people's grace. How frequently would you monitor the suppliers once they've got contracts in place and maybe they've got obligations on you?
Well, the obligation under the Act is to produce a statement every year, and you would normally have to publish it within 6 months of the end of your financial year. So it kind of ties in with your annual financial reporting. So the answer is, the easy answer is every year. One interesting thing, I think, the government has asked and suggested that once you start publishing a statement, you should keep them up on the website, so that people who are wanting to look at your credentials, looking at what you do, can see year on year what you're doing, and it guides against the possibility that you just produce one generic statement and then put it up every year. So I think it is good practice. It's onerous, but it's good practice to keep each successive year's statement there, and to be able to demonstrate that you're going back to those suppliers every year and challenging them every year. So once a year would be, this is a simple answer.
And I think, like a lot of subjects too, managing this properly is not just because the law says that you should, it's because it's the right thing to do, particularly in some sectors, especially if you've got a valuable reputation to protect.
I mentioned earlier on that the PR consequences of not producing a good statement and then something going wrong could be absolutely disastrous. Yeah. And I promise you, you can produce a perfectly good modern slavery statement in about 2 hours if you put your mind to it. So it's just a very worthwhile thing to do, and I think companies even that don't need to do it really should.
Well, look, Jim, thank you very much indeed for joining us today. Thank you for an excellent presentation, and thank you very much for our members who joined this webinar and others who have dialed in. We really appreciate you doing that. And again, just one final mention, do let us have your feedback. And thank you very much for joining us today. Thank you.